All these human rights instruments you see here, the main 9 core ones that protect fundamental human rights, have monitoring bodies known as treaty bodies or committees even. Okay, that was quick. Now, the International Covenant on Civil and Political Rights, which you can find there at number 8 and at number 7, those perhaps you can call the parents' treaties. Perhaps, if you like, umbrella treaties, and I've abbreviated them to ICCPR and ICESCRs. From them, I believe, or you can argue, spawned right-specific treaties, or other treaties that then were subsequent and perhaps elaborated on the provisions contained therein. I've got a few examples here, and I'll just refer to Article 3 of the ICCPR, but 2 and 3 of ICCPR and ICSR are relevant here. States parties to present covenant undertake to ensure the equal rights of men and women to the enjoyment of all civil and political rights. Gender equality is pretty much the main theme there, and that was greatly expanded upon on the Convention on the Elimination of All Forms of Discrimination against Women. Again, with Article 7 of the ICCPR, that's the prohibition of torture, against torture or cruel, inhuman or degrading treatment or punishment. Then we had a big treaty established from that, which is the Convention Against Torture. And Article 24 of the ICCPR pertains to child rights, welfare, protection from sexual slavery, exploitation, etc. Those 3 subsections of 24 created a big treaty again in the Convention of the Rights of the Child. Now, however, these do, the point here is they overlap. All the main provisions specified in the parent treaties have something in common that resulted in subsequent treaties. The compilation of guidelines on the form of content and reports submitted by states party to International Human Rights Treaty, this is the name of a document, on the 7th of May 2004, is, conveyed that the Convention on the Rights of the Child and the ICSCRs require states to submit information on children and their protection from sexual exploitation and labor, as well as infant mortality and healthcare during pregnancy. 2 state reports are therefore required. One of the same details as you have above to the Convention on the Rights of the Child, the Committee on the Rights of the Child would then address, and the same set of reports would then be forwarded to the Committee on Economic, Social and Cultural Rights. So here in essence we've got one state has to send out duplicate reports to 2 separate committees, thus taking up more time and resources. And these committees aren't really within their remit. They cannot share these information with each other or cross-reference. So everything's pretty much austere, black and white, rigid. We need one state to give us this report, a same state to give us this report, even though it's pretty much the same thing. This chart here represents the number of ratifications per state. This is just to give you an idea of how overworked states as well as committees are. As you can see the bar graph there, 193 states have ratified and signatories to the Convention on the Rights of the Child. That means 193 states have the reporting procedure to the committee. So you think the committee receives about 193 of these periodic reports just on the Committee on the Rights of the Child alone. If you come along the charts, you'll see the ICSR has 160 member states, parties rather, excuse me. ICCPR has 167 member states. So on average, we've got about 160, 148 states per treaty. Average is about 281 periodic reports submitted annually, if we break it down into every year rather than every 543. We take the average every year, 281 reports are submitted. For each committee to receive that many reports, highly, highly overworked. Practically impractical. Basically, each committee receives lots of reports, and to illustrate how many reports it is, just for the Convention on the Rights of the Child, the committee receives a 50-page state report. That's just from the one state. And here we've established that there's 193 of those states. That's a lot of paperwork coming through. It's been proven that it takes about a 17-month delay between the time states submit those reports to the time the committee has concluded and addressed those reports. There's a 17-month delay. Now, that's a lot of work for these committees, these treaty bodies, to keep an eye on how states are implementing international human rights law, making sure that they're not abusing or violating. That does not factor the extra work, which is found in the individual complaints petition or mechanism. So an individual who suffered human rights abuse by their state or in their state wishes to make a complaint to the relevant treaty body can do so, and that creates more work for the treaty body. Individual complaints are provided for either in treaties, in treaty provisions, or by optional protocols. It is through individual complaints that human rights are given meaning. When applied to a person's real-life situation, the standards contained in international human rights treaties find their most direct application. When applied, here's the problem. 189 of the 192 United Nations member states have not ratified the optional protocol to, for example, this instrument there, International Covenant on Economic, Social, Cultural Rights. That optional protocol provides an individual complaints mechanism. Without it, people who suffer those human rights abuses cannot complain. That has not yet entered force. Again, we have with the optional protocol to the ICCPRs, of the 167 states that have ratified the ICCPR, only 79 have provided agreements to follow the optional protocol and provide an individual complaints mechanism. There's a lot of backlog, unfortunately, as a result of all these individual complaints that come into the UN. And committees take several years, and that's quoted on the UN website, several years for them to go through the whole case, conclude, and issue a decision. If you look at the last one there, in the last just under 3 decades, 418 cases out of the 1,171 cases submitted to the Human Rights Committee, the Committee on Civil and Political Rights, were decided. That's less than 36% of those petitions. There is a fundamental plethora, backlog of complaints coming into the committee. On top of that, they have to address state reports as well as these individual complaints. It's a monumental task, and they're unable to keep up, and they're drowning in the work. Instead, in their ingenious way of thinking, I say that with a touch of sarcasm, committees came up with a common core document, and that's the authorizing document in which that idea was explained. However, a common core document where all the states would submit pretty much a whole unified state reporting, but they said, on top of doing this, we expect you to submit an additional routine report under each treaty. So again, they're bringing back the same problem. We're going to consolidate, but we expect you to also provide some information separately. So that's, I don't know, in my mathematics, isn't that creating more work? Because the enforcement of international law isn't for obedient states. Which obedient state needs enforcement against them? It's for recalcitrant states that needs a remedy. And in the words of Steiner, it is indeed unclear whether making binding views would improve the spotty record of compliance. It's the recalcitrant states that we need to address. Thank you for your patience.
Thank you very much.